My name is Sanja Bornman. I am an attorney and one of the directors at Dignity South Africa. And we're delighted to see so many people joining us. We hope you're going to enjoy tonight's webinar and find it very informative. Full disclosure, we are recording the session just so that everyone is aware. Tonight, I'm going to be in conversation with a guest, and after that, we will discuss your questions and your thoughts. So we would like to invite you to pose your questions in the chat as they come up for you. And after the discussion, we will answer them for you as fully as we can and in the order in which they appear. So please do begin your questions by introducing yourself with your name, and you can also tell us where you're from. If you do have a burning question tonight that we don't get to because of time, please feel free to get in touch with us at any time after tonight using the contact information that you'll find on the website. So we have these Dignity Dialogues every month, thanks to our wonderful manager, Lee Maynard, who will say a few words a bit later. And you can catch up on previous dialogues on topics like law reform and what it feels like to live with motor neuron disease on our YouTube channel. Speaking of law reform, you will have seen and heard quite a bit about Dignity South Africa in the news since last Thursday, when we launched our constitutional case in the Pretoria High Court for the decriminalization of medical assistance in dying. If you're curious to know more about that, you can read our application also on our website, and you can follow us on social media for updates and developments as they happen. But tonight's Dignity Dialogue is not about medical assistance in dying. Tonight, we're going to talk about advanced healthcare planning more generally, the stuff that should happen before illness and mental incapacity knock on your door, leaving your loved ones to wrestle with very difficult medical decisions about your care, and too often they are wrestling with each other in situations like that, not knowing what you would have wanted in respect of consenting to or refusing medical care, and what you would have chosen for yourself if you could. We are specifically going to zoom in on a very little known legal mechanism that is buried in the National Health Act. And it's a mechanism that anyone can use to make sure that your end-of-life wishes are not only respected, but followed by medical practitioners when you can no longer speak for yourself. And this is what we call your Section 7 mandate. Joining us tonight to explain what a Section 7 mandate is and how it works is our special guest, Rhiannon Thomas. Over 2 decades of legal experience, Rhiannon is not your typical attorney. She is a notary, a conveyancer, a wills and estate specialist, but she's also a pioneer in the field of integrative law. Her approach to law is a lot more human. It's rooted in connection and collaboration and conscious practice. And at Milkwood, which is her legal practice, she helps clients to navigate life's transitions with care and with compassion. She's particularly passionate about helping clients who have a serious diagnosis to get their end-of-life documents in place. And for this reason, she's very well placed to be with us tonight. Very welcome to you, Rhiannon, and thanks for joining me in the hot seat tonight.
Thank you. Thanks for having me.
Okay, let's kick off straight away with what I'm sure is by now at the top of everyone's mind. What on earth is a Section 7 mandate?
So a Section 7 mandate is called that because it appears in Section 7 of the National Health Act. And in the National Health Act, there are 3 very important sections about consent to medical treatment. Section 6 particularly talks about what needs to be explained to someone who is being treated, their rights around what they should be told about the risks and the complications and the benefits and their health status, all that information that should be given to them. And what's in section 6 is really the basics of the concept of informed consent. So it's not enough just to consent to something, well, to medical treatment. That consent needs to be informed. So all the information needs to have been presented to the patient, who the Act calls the user. So a user is a patient or someone in a healthcare facility who is going to have treatment administered to them. And then Section 7 particularly talks about how the consent should be given or obtained. And then Section 8 talks about the right of the healthcare user to participate in decision making. So it's not a doctor knows best approach where you're just informed about what's going to be done to you. There's actually a right of participation. So, and for anyone who can understand, it also covers cases where a person might not necessarily be able to give informed consent, but has enough ability to understand the basics. They still need to have the information explained to them in a way that they can understand. And so coming back to Section 7, which is particularly around obtaining consent, the Act sets out, firstly, that in order for a person to receive any kind of healthcare treatment, they need to give their consent. And then it amplifies that into the different ways that consent can be obtained. And the main way would be from the user, so the person themselves who's being treated. But it also has a section that says that consent can be given by somebody else on behalf of a user if that person has been mandated in writing to consent on their behalf. And then because it is a right, it means that a medical professional, any person who, it's not just, it also applies to, it applies very broadly to people in healthcare, that if someone has been mandated, that person is able to consent on behalf of the person that can't give their consent for some reason. And what they say must be followed. And they must also be included in the right in Section 8 to participate in the decision. So to be given all the information, participate in the decision, and then to consent on behalf of the person who's unable to give their consent.
Okay, great. So it is a written document, right?
Correct.
And if I'm the patient, for example, and I am in a situation where maybe I'm in hospital and I'm unable to communicate, I'm unable to make decisions about my healthcare in that moment. And now you need to decide whether I should go on a ventilator or whatever. Is this a situation where I can give someone like you a written mandate to step into my shoes and make that decision for me?
Exactly. That's exactly what it is. So it's when
Okay.
if you were the patient, if you were unable to speak for yourself because perhaps you were unconscious, perhaps you're in a coma or in a medically induced coma, or you no longer have the ability to make rational decisions because of some kind of mind affecting illness, then if you have mandated me as your person in terms of Section 7, whoever is treating you has to come to me for consent or refusal. So the Act specifically mentions the right of refusal of healthcare treatment as well. So consent is not just saying yes, it's also having the right to say no. Actually, we're not going to put them on a ventilator. That's not what they would have wanted. And then what I say as the mandated person is, as though I am you, as though I am speaking your words. So the authority then rests with the mandated person.
So it sounds like when you are thinking of giving someone a Section 7 mandate, which sounds like a pretty excellent idea because none of us know what's going to happen tomorrow, it should be someone that you trust and someone that you know is going to carry out the wishes that you have discussed with them.
Absolutely. So it's especially pertinent to people who don't have a close family member that they trust implicitly about making decisions on their behalf. But even if you have a close family member, you can mandate them, and then you've got the mandate in place, which has to be followed. And it has to be someone who you trust to make life and death decisions, because they can make whatever decision they make, even if somebody else comes along and says that's not what they would have wanted. If they're not the mandated person, them saying that doesn't have any sway at all. It's the mandated person's, what they say, that's what will have to be followed, and that healthcare professionals are bound to follow. So definitely somebody that you trust and somebody that knows you really well. And, ideally somebody you've had conversations with about what it is you would want in certain situations, because there will undoubtedly be times when the mandated person has to make a decision and may not actually have had that particular conversation with the patient, but still has to have the responsibility of making the decision on their behalf for them.
Understood. And so it sounds like a Section 7 mandate is a really good way to make sure that family members or friends or loved ones aren't left in a situation where they have to fight with each other. Because often we see, at someone's bedside, there's more than one person who really loves them, who feels like they might know what's best for the patient. And they may not be agreeing with each other over what the next step should be. But from what you're saying, a Section 7 mandate person would be able to step in and say, actually, they gave me the right and the power to make these decisions on their behalf. And so you might as well all stop fighting. I'm going to call it. Is that correct?
Absolutely. And I think it's especially pertinent to people where the people who would be approached for consent would be the children. So you might have someone who is a patient and unable to speak for themselves, and they have 3 children. And all those 3 children have a say. So then you're stuck with them arguing about what should happen. Whereas if a mandated person had been appointed, they can then make the decision and take responsibility for that. And sometimes in practice, I have seen people mandate one of their children to be their Section 7 mandate, because that's the person that they have discussed things with and who knows what it is that they would want.
Excellent. So this is definitely, it sounds like these 3 sections, 6, 7, and 8 together form a basis, a good legal basis for advance directives, specifically the Section 7 mandate, which is given to a specific person, right? But how is that different from other kinds of advance directives? So, for example, we have a lot of people in South Africa who make living wills. So what would be the relationship between a living will and your Section 7 mandated person?
So the Section 7 mandate is legislated. It's part of our law. It specifically states that the mandated person can make decisions on behalf of the person. It gives them a right, a legal right in law. A living will is not legally recognized in South Africa. They're more ethically recognized. So when someone who's treating a person is presented with the living will, and the person is in has a terminal condition and there's no prospect of their reasonable recovery. It's really just a matter of sort of keeping them alive. They will then morally and discussing with the family, whoever the people are who give consent, and bring that into the discussion. However, it doesn't have the same legal weight that the Section 7 mandate has, in that we know that that is part of our law and that the mandated person's decision must be followed, whereas the living will is merely just an expression of what the person would have wanted and could be followed. And the thing that happens often in these cases is it really depends on who the attending person is, who is treating the person. They may decide, okay, there's a living will, I feel ethically bound to follow that. But they may also view that life is, sacrosanct and that we can't interfere. So they would potentially then keep on treating the person regardless of the living will because they're not required to follow it. It's really just an ethical decision on the part of the treating physician or doctor or whoever it is. So you never know if your living will is going to be followed or not. It's merely just giving more insight into what the person would possibly have said or would have said if they could speak for themselves.
Okay. So it sounds then like a Section 7 mandate has a lot more legal power than what a living will currently has. Do you agree with that?
That's correct. So if, for example, somebody has given someone a mandate and the attending physician refuses to follow what they say, you could then have a legal action based on that. You would have an urgent application to court to get them to follow the mandate because they have to follow what the person says. There is no debate about that. Whereas if they decide not to follow the living will, there's nothing you can do. You really are just relying on their goodwill or their morals. And not everybody has the same morals or same ethical viewpoints on, especially on something as emotive as choosing to withdraw treatment from someone or not to treat in a particular
Absolutely.
situation. Yeah.
And what about things like a do not attempt resuscitation order?
So those tend to be done within healthcare facilities. When someone is admitted, they might be asked if they would like to sign something like that, which then is again a wish not to be resuscitated or not to have any intervention if they, have a cardiac arrest or something like that. But if the physician decided that they were going to try to resuscitate, there's nothing you can do to stop that. Again,
Wow.
it's more a clinical thing that's used in hospitals and instructs the medical staff, and the doctor is the one that makes the final call there on whether or not to carry on with treatment. But it only relates, it's very limited. It's really just for resuscitation. So, basically putting on the, I don't
Yeah,
know the term, but, bringing
indeed.
somebody back to life.
Yes.
So it's quite a limited thing. Whereas the living will, generally people's living wills will cover a number of scenarios, like not to be fed through a nasogastric tube or
Yes.
not to be given food intravenously, things like that. So that's a much more involved document than a
Understood. And I think one of the documents where there are a lot of misconceptions is the general power of attorney. That is a document that only is valid for as long as the person who gave it actually has mental capacity, right? And a lot
That's
of people think that it functions as a kind of Section 7 mandate when actually it is a completely different kind of a document.
Yeah, so general power of attorney doesn't relate to healthcare at all. It has no application in that area. It's related to financial decisions, and it only applies for those, and legal decisions. You know, whether you're going to sell somebody's house or you're going to deal with their medical aid. That's probably as close to health as it would come, is the right to deal with the medical aid. It only lasts as long as the person has capacity. And the thing about the Section 7 mandate is that it's implied in the Act. What's more than implied, it's quite clear. It's not implicit, it's explicit that the Section 7 mandate will apply when the person doesn't have capacity because they're unconscious, for example, and they can't speak for themselves, or they've lost their capacity because of an illness like a degenerative illness like Alzheimer's or some form of dementia and can no longer make decisions for themselves. Whereas the general power of attorney is only valid when someone has full legal capacity.
What about an enduring power of attorney, or what some people call a lasting power of attorney? Is that something we have in South Africa? If the general
So,
power of attorney is not going to help you, if you become incapacitated, is an enduring power of attorney going to assist?
So if you lived in another country, like the UK or in some European countries and in America, then there is this concept of an enduring or lasting power of attorney. And why it's called enduring or lasting is because it lasts beyond the capacity of the person. So they
Ah,
make it when they have capacity,
mm,
saying that when I lose capacity, this document will give somebody the right to make decisions on my behalf. And generally, there are separate enduring or lasting powers of attorney for financial matters, and then one that's particularly for a health and welfare. But this is not part of our law. We do not have them, they do not exist. Um, and they fall under this concept of an advance directive. So
mm.
people often think of that when they think of an advance directive, but it's definitely not valid in South African law. And the only thing we have in South African law that is an advance directive that will endure after the lack of
Mm.
capacity is the Section 7 mandate.
Okay, so advanced directive is an umbrella term for all of these things we've just discussed. And if
Yeah,
you
so
want to make sure that your wishes are going to be respected when you can't make decisions for yourself anymore, the Section 7 mandate comes out tops. Is that
yes,
right?
yeah, in our system, that's what comes out tops. And yes, it is an umbrella term. So all of those documents are advanced directives in some way, except maybe for the general power of attorney is saying if something happens in the future and I'm unconscious and you need to, contact the medical aid on my behalf, then you can do that. As long as the person well, I suppose if they're unconscious, they don't have capacity. But let's say they're too frail or infirm to go on the phone to speak to the medical aid, then it's somebody else can speak on their behalf or into the bank.
Okay.
Yeah, they're often used with banks for things with the bank.
So, I mean, that to me is quite mind-blowing that there are all these things that we think we should have, and people are putting a lot of time and effort into putting them together, when actually it's the Section 7 mandate that's the most powerful instrument here. So, why do so few people know about it? Why do so few doctors or lawyers even know about it?
It's such a good question, and I think there's a variety of reasons, but I think the main reason is that it's kind of hidden away in the National Health Act, um, and that lawyers are generally the people who read legislation. It's the kind of thing we do to get to sleep at night. Not really, but
Maybe
we are
you.
expected to keep up to date with legislation. However, the lawyers that work in the area of end of life documents and wills and estates wouldn't think, unless somebody pointed it out to them, that they should read the National Health Act, because the National Health Act doesn't come into that part of law really, but actually it has something in it that is very important for the area of advanced life, end of life planning. And so I think many lawyers just don't know that it's there. Or if they have read the act, haven't made the connection between, here is something that is very powerful, where a person can actually mandate someone to consent to treatment or refuse treatment on their behalf. And then when it comes to the health professionals, they don't read the legislation. And I think it's just been missed, because it's certainly not mentioned in the Health Professions Council guidelines or anything like that. And I think it's just a lack of information, a lack of knowledge. And the National Health Act came into law in 2005. So it's 20 years ago. And yet we don't see the Section 7 mandate being commonly used by people. It's very, very rare to see it actually used. And obviously that's our goal, is to change that, to get people to know about the rights that they have and be able to exercise them, to be able to have more control over the kinds of decisions that are made for them when they can't make decisions themselves.
So basically, it's just a lack of knowledge. It's a lack of public education. It's a lack of, I mean, what normal person just goes and reads legislation, as you've said? No one. So it's really just been hidden away, even though it is the most powerful advance directive that we have.
And
It
yeah, and I
sounds
think the
like,
National
yeah.
Health Act is a very dense document. It's a long act because it covers everything around health. So when it was drafted, it was a consolidation of a lot of different pieces of legislation into one piece of legislation. And so before we had different things about, and there were different pieces of legislation relating to smaller areas of healthcare. And then this big act was created. And I think it's just overwhelming as well. So that's probably also part of why people don't know. But there's definitely been no public education around it.
Well, I think we're going to have to definitely fix that.
We'll have a
So,
roadshow.
yes, 100%. Okay, so let's talk a little bit about what this thing looks like. So we've spoken now a lot about what it does and what it does not do. It allows someone to say yes or no on your behalf when it comes to healthcare treatment. Is this a very formal document? Do you need a lawyer to draw it up? Do you have to have witnesses, or does it have to be notarized? Talk us through the sort of bare minimum requirements of what a Section 7 mandate would have to be.
So the National Health Act, has tried very hard to make many things accessible to the ordinary person. And the wording of the act is basically that no treatment can be provided to someone without their consent. Okay. And if the person is unable to give their consent, the consent is given by a person mandated by the user in writing. That's all it says. So it doesn't say what it has to look like. It doesn't have anything about needing witnesses. So really, one could have a piece. The main thing is that it has to be in writing. So if I find a piece of paper and I write on there, I, Rhiannon Thomas, hereby mandate Sanja Bornman to give consent on my behalf to medical treatment and sign it, that is a valid Section 7 mandate. There's no magic involved. There's no need for lawyers, and there's no need to pay someone to do one for you. Where you might, and this is the example of the one that I used, does look to try and make it look, formal, but it doesn't have to look like this. So it really just has the patient's name and their identity number. And then it says, as provided for in this part of the National Health Act, I mandate so-and-so to be my healthcare decision maker. In fact, that's all you would need to write. I mandate so-and-so to be my decision maker. That would be fine. I fleshed it out because it's helpful for people to understand what it is that they are signing.
Yes.
And in my practice, what I do is I do offer living wills, because living wills do have a large role to play in that they inspire conversations around end-of-life decision-making, but they also flesh out people's wishes. They see this living will and they think, oh, yes, I definitely want that. But no, I do want to be fed. Or I don't mind being intubated, but I don't want to be I don't want to be in pain. So I'll say that you can give me extra pain medication, even if that might make me die more quickly than if you didn't give it to me. So it can be used to flesh out the rights of the mandate holder. And you could write a long Section 7 mandate saying, these are the things that I think about treatment. But at the end of the day, if the person that you've mandated chooses differently, they can choose differently because it's what they choose, not what you choose, but they are supposed to be acting on your behalf. But if they make a decision that's contrary to what you would have done, they wouldn't be held legally liable because you've mandated them as being able to speak for you.
Which I think, again, really emphasizes that you must choose someone that you trust and someone that you've had these conversations with. And I also imagine that, even if you do draw up a living will, you can't really imagine every single possible health scenario. And so your Section 7 mandate person is probably going to have to make the best decision they can, knowing what they know about your wishes with the information that is made available to them at the time.
Absolutely. So, for example, you and I know each other, but we don't know each other that well. If I made you my mandated person, you would then think, okay, well, Rhiannon helps out at DignitySA sometimes, and she's quite passionate about medically assisted dying. So she probably doesn't want her life to be prolonged unnecessarily. But that would all be a thought process that you would have. And if you decided, okay, switch her off, that would be fine because that's your decision to make as my mandated person. So it is really important to choose someone who you've had conversations with because they can't know everything. And of course, a scenario will come up that they might not have considered, and then they will have to make their best guess as to what the person would have wanted and make a decision for them.
Okay, so let's imagine I don't have a Section 7 mandate person. I end up in hospital and decisions have to be made about my healthcare. What does the Act say about who's going to make those decisions if I don't have a Section 7 mandate?
So if you don't have a Section 7 mandate and you can't make the decision, the Act does say who must be approached to get consent. Because if treatment is administered without consent, that constitutes an assault in our law and is against the law. So you cannot give treatment without it's not just consent, it's informed consent.
Mm.
The act then sets out a list of people that a person would have that the attending physician would have to approach, and they're on the screen now. So the first person is the spouse or partner, and I don't think this covers partners as in I'm going out with someone, we're not married, and I call them my partner. What that word partner refers to is the civil unions, the idea of a partner in a civil union. So someone with,
Understood.
it's not just your significant other. So it's the spouse. And then if there is no spouse, then the parent of that person. And if there's no parent, then the grandparent. And then only if there's a child, it must be an adult child. And if there's no child, a brother or a sister. And where we get stuck on things is there's only one spouse. And I suppose in some customary marriages, there might be more than one spouse. But there might be more than one parent or grandparent or child. And that's where you have people having disagreements about what needs to be done. And what I find quite interesting is in my own particular situation is so I'm divorced, I don't have a spouse. My parents are dead, I don't have a parent. My grandparents are long gone, I don't have any grandparents. So the person, if I haven't mandated someone, is going to be my 19-year-old son who is going to have to make a decision of life and death. And that just doesn't seem right to put that
Yeah.
on someone who is 19 years old to decide whether his mother should be kept alive or not, for example. So, when you think about the practicalities, it really does make sense to, even if you have a spouse, appoint that spouse. Or if you have children, choose a child. And the other thing that's valid it doesn't say you can only appoint one person. It just says a person appointed by. So you could mandate more than one person, but then you run the risk of them disagreeing.
Yeah.
So, yeah, so I do mandates where people appoint more than one person and want them to discuss it, and then they would have to come to an agreement between the two of them or three of them. Or sometimes it's because people have children living overseas and they might not necessarily be available right away. So they've got an alternative person. So it's not and. So I can go to A. If I can't get consent from A, I can go to B, and B's consent will be valid.
Okay. So does this mean that all of us who have living wills must now go home and shred them and forget about them? Or, I mean, explain to us how the living will can complement the Section 7 mandate, if indeed it can.
Yes, so I don't think you should shred them. I think they're valuable documents because they give a lot of evidentiary value as to what somebody would want. But I think that they should maybe be revised so that the spokesperson, because often in a living will you appoint a spokesperson to speak on your behalf, is the same person as your mandated person. And then to link the two documents together so that your mandated person knows that this is how you feel about end of life decisions. Because of course the living will only applies when there's no reasonable prospect of recovery of a rational existence. So the person is dying. They are going to die. There's no doubt about that. It's just a matter of when. So we can keep them alive longer by giving them more antibiotics or feeding them or continuously giving them insulin if they're diabetic. Or we can say they are dying. So someone, for example, I was a mandated person for someone who was a diabetic who had cancer, and she was, if terminal, going to die. And then we decided not to carry on giving her insulin because it did speed up her death. She would have probably lived a few days longer if the insulin had been administered as well. Yeah.
So, if you could give one piece of advice to people in tonight's webinar, who maybe are hearing about Section 7 for the first time, what would that piece of advice be?
So it's important to think about these things, and to have discussions with people. It's important to think about who you trust to give consent on your behalf. And then I would say appoint a person, right? Speak to somebody and tell them if if I am in a terrible accident and I'm unconscious and I can't make decisions, I would like you to be my mandated person. And this is how I feel about life and death. Um, I value quality of life over quantity of life, or I value quantity of life. So keep me alive at all costs. If they offer me antibiotics, say yes, and someone who you really trust. But I really think that it's important to have the mandate in place. It's less important for people who have a spouse that they trust, or a parent, or a grandparent, or an adult child, because those are going to be the people that they go to. But there are many people that are like, the last person I would want to decide is my mother. And I would rather my long-term partner, significant other, not partner, who I've been in a relationship with for 20 years but never got married to, that they're the one who makes the decision, not my parent. So it's important to really think about who your person would be if you didn't mandate someone, and then is that person okay? Is that the person you want? And if it isn't, then to appoint a Section 7 mandated person.
Thanks very much, Rhiannon. I think that's good advice.
Yeah.
Anyone who's over the age of 18 and has mental capacity should think about a Section 7 mandate, because we don't know what's going to happen tomorrow. I'm going to turn to the comments. Let's see what some of your questions are. We've got Yvonne Spain from Howick. She says her daughter Jo from Pietermaritzburg is also attending tonight because she is Yvonne's mandate holder. That's very lovely of the two of you to be here and to bring your Section 7 mandate holder. We hope you've learned something from Rhiannon tonight. Then we've got Willem Myberg from Cape Town, who says that he works in aged care. And how does this section apply to long-term aged care? Is there anything that you have to do differently in that kind of scenario?
I don't think so. I suppose the only thing that the person may want to review who their mandated person is. But as far as people in aged care, I think it's really, really relevant for them to have somebody that they trust who can consent on their behalf if they're unable to, especially as we've got such an increase in, dementia types of illnesses where people lose capacity. And this is a document that actually lives on beyond the loss of capacity of the person, which of course the living will doesn't have that power, and any powers of attorney or anything like that lapse. So that's the Section 7 mandate is something that's really, really important actually for older people.
Willem also wanted clarity on the relationship between the Section 7 mandate and the Advance Directive. But I think we've explained that Advance Directive is really an umbrella term, and that there are many kinds of Advance Directives, with the Section 7 mandate being really the most powerful and most legally reliable in South Africa.
Yeah.
Excellent. Then we have a question from Anna-Marie Hendricks. Can there be a backup person within the Section 7 mandate? So if the one person is not available, can there be a second mandated person? I think you answered that one as well, Rhiannon, that you can mandate potentially more than one person.
And I think it's important to to know for the difference, as lawyers, we love words and words are very important in law. So there's a
Yes.
difference between and or. So if you have as mandated, I mandate Sanja Bornman or Lee Maynard, then it's not that both of them have to consent. Either one of them can consent. So yes, you can put more than one person. And I would use
Okay,
or
so
between
so
them.
it's good to have a backup, in other words.
Yes, yes, because
Maybe they
that
can't
person
get
might not
hold
be
of the one
available.
person. Yeah.
Exactly. Yeah.
Okay. Karen Pitts wants to know, how does it work if you have a living will? And I think here you've indicated, Rhiannon, that you really should combine your Section 7 mandate and your living will so that you are designating the person who's going to make the decisions, but at the same time, the living will is a document that can inform that person in quite a lot of detail what it is that you would and would not want at the end of life.
Yeah. Yeah.
Right. Then we've got Anne Tottill, who is from Bern, KZN, and she'd like to know how this is panning out with hospitals and healthcare providers in practice.
So that's a good question. My own personal experience has been that it's always been followed, um, where um, where it is presented, because people do go and find out whether it's a real thing or not. So there is some kind of knowledge that you can mandate someone. If they didn't follow it, then you would have to take legal action. And that could, of course, be a long and lengthy process, but it could be done on an urgent basis. But my sense, especially from medical professionals working in end of life, particularly, they do know about the Section 7 mandate
Oh,
and they
good.
do follow it. And I think that part of our vision for the Advanced Directives campaign is to, educate, to really educate healthcare through various organizations about this document. Yeah, but that's
Critically
for my
important.
anecdotal knowledge. I can't really say, there's been no research or anything like that.
That's maybe something we should think about.
Hmm.
Next question is there a checklist for appointing someone to be a Section 7 mandate? I think that's a very good question. I've lost sound for Rhiannon.
Can you hear me now?
Yes, we can. Please go
Oh, that's
ahead.
good. Okay. It's my internet connection is unstable. That could be my teenager gaming in the other room. So
Okay.
let's hope it slows down. It doesn't slow down anymore.
Yes.
Yes, I think that's a really great question, and I think some kind of checklist could be useful. Like, who do you trust? Who knows you well? Somebody who's robust, because sometimes the you knows the patient the best, that they wouldn't want the treatment, but you're dealing with a doctor who's particularly focused on saving lives at all costs and is going to try and talk you into doing this other intervention that the person wouldn't want. And there's a power dynamic there. So you
Yes.
need to be someone who can speak up for you and who isn't afraid to perhaps have a heated discussion with somebody in a position of power.
Thank you very much. Next question. Who can legally compile the written mandate? Is it not the same as the Advanced Care Directive?
No, so I don't know. I mean, when you say advanced care directive, I'm not quite sure what you mean by
So
that.
that's the umbrella term. So
Okay,
an
yeah.
advanced directive is the umbrella term, with the mandate
So,
being one
yeah. So, I
kind
mean, a
of.
living will doesn't have to be written by a lawyer. A living will can be written by yourself. You can write your own living will. It's just that lawyers tend to have templates of these documents and then tweak it. Well, if they're good, they'll tweak it for you. They won't just impose it on you. But the Section 7 mandate, anyone can write that. And as we said, it can be in any form whatsoever, even on a napkin. If you wrote it on a napkin and signed it and gave it to somebody, that's the Section 7 mandate. It just has to be in writing. Yeah, so there's no real sort of requirements, doesn't have to be witnessed, doesn't have to be notarized, doesn't have to be stamped by a commissioner of oaths, nothing like that.
So you just have to be 18 or older,
Yes,
and you have to have the mental capacity to write the document, and the rest is just really write it down, designate your
absolutely.
person.
Yeah, yeah. And I mean, that's something we haven't mentioned is it might be useful to write out a few. I mean, you could type it out. Doesn't in writing doesn't necessarily mean handwritten. It
Written by
obviously
hand,
would
too.
need to be signed. And I would think you would need the original, but maybe not. Maybe a copy is acceptable. But give one of these to your mandated person and maybe to your doctor as well. Or if you live in an aged care, to the manager to put in your file so that they've got that. So you could have, more than one copy. Originals are always best. But there's nothing to say that a photocopy of it is not valid. It's in
Thanks. I think
writing.
that's good advice.
Mm.
Definitely have more than one and make sure that your person has a copy of that document that they can present if they need to.
Yes.
Then there's another question about where the mandate should be lodged. So again, is this the kind of document that you would have to go and specifically ask your attorney to keep for you? Or
Yeah, so I think that kind of thinking comes from a long time ago. Wills used to be lodged with the master's office. That no longer happens. So these days, banks will charge you a monthly fee to keep your will or whatever, but there's no legal requirement for wills to be lodged. And there's certainly no legal requirement for a Section 7 mandate to be lodged anyway. So it really should be with your important papers, and somebody should know where it is. It's particularly the mandated person. I would give mine, so I've done one, and I've given it to my mandated person, so they have it in their important documents. I don't have mine on me because I'm going to be unconscious at the time, and hopefully somehow my mandated person will find out and come and give consent. So that's actually something I haven't thought about. I haven't told my son, who would be the person that they would go to, who my mandated person is.
yes.
And I should tell him so that he knows that she is the person that I want to make the decision on my behalf, not him.
Again, very good advice. Then we have a question about capacity. Carol is often asked for assessments as to capacity to draw up these contracts, mainly different kinds of advanced directives, but not yet Section 7s. What is the legal route with regards to reports from a psychologist? How legal and valid is that report, and what is required in the report? And I presume that this would be where you ask a psychologist to evaluate whether someone has the capacity to write their Section 7 mandate.
So the basic rule is that capacity is assumed. So you assume that somebody has capacity to write a Section 7 mandate. If their capacity is somewhat impaired, they might have enough capacity to write a Section 7 mandate. And that's when a psychologist would come in to be able to write a report to say, when this person drew up this mandate, they understood what they were doing. They understood the implications. And they did appreciate that. They might not have full capacity in that they can't, their memory isn't great, for example. But they can have conversations about things and at that time know exactly what it is they want. Once the mandate is done, if somebody comes along and says, but that person didn't have capacity when they did it, they would have to prove that. He who alleges must prove. So
Yes.
until it's been proven that they don't have capacity, it's assumed that they did have capacity.
Hey. Then we have a question about the required format from Christine. Christine, I think you saw what we put up on the screen, and in a couple of minutes, Leah's going to direct you to some resources that you can download for very easy use. Willem says, wow, so simple yet so profoundly powerful, right? It's
Yeah,
quite
it
an
is.
eye-opener.
It's simple.
It's quite mind-blowing that there's this thing in our law that nobody seems to know about that is so easy to put together.
And I
Yvonne
think,
Spain then says she's trying to buy a DNR bracelet and doesn't want to use Temu. Fair enough. I think that's excellent, Yvonne. Does anyone know where she can buy one locally? And then
I have seen, you
Willem
can
has
have,
put a link in the chat. So thank you very
yeah,
much, Willem, for
there are
that.
some local places, yeah, and so you can have that. I did meet a woman at a frail care who had it tattooed on her, so she had DNR
Okay.
tattooed. In
Wow.
case she got to the state where she had lost her marbles too much to remember to wear her bracelet. And I thought that was really clever, actually, to
A bit
and
extreme, though, but I guess
well,
needs
and quite
must when the devil
committed.
drives.
She knew
Okay.
what she wanted.
Yeah. And wanted to know what happens if there's no one at all from that list that we showed on the screen.
Yeah, so it does deal with that in the act. It says then it would be done in as a kind of, I think it says um, that the decision would then be made in the best interests of the person.
So
So
it's going
that
to
would
be
be
the medical team at the end of the day is
yeah,
going to
that
have
would
to
be the
decide
medical
for
team
you.
deciding. Yeah. And obviously in an emergency situation, you wouldn't necessarily go to the mandate because you
Mm.
find the mandated person if the mandated person isn't there. So in an emergency situation, consent can be, you don't need consent. And the act also talks about if you're not able to get consent, you do have to afterwards explain to the person what happened, and try to get their consent as well. So it does deal with that.
Okay, great. Then there's a question about having more than one mandated person. Are you going to have to list both of those people in the same document, or do they both have to be present when the decision is made at hospital? I think we've discussed this a little bit.
Yeah, I would say I would put the names on the same document, and I would say alternatively or so that then implies that you don't need them both to be there. It's just one of the two of them needs to be there. I mean, you could write that, you could say on your mandate, and I mandate this person, but if they're not available or unable to come and consent on my behalf, then this is the second person that you need to ask.
Then Christine says in many overseas countries, the advanced directives combine the mandate, the health proxy or the Section 7 mandate, and the living will conversations. Does Section 6 not cover the options informing the user and the mandated person? So for example, what would CPR involve or stopping treatment, so on?
I'm not quite sure I understand the question because Section
I
6
think
is
what she means is that in a lot of countries they sort of have they combine their Section 7 and their living will. And I think what she is wanting to know is when the doctors are discussing your healthcare options with you as the user, does your mandated person have to be there to hear the
oh no, not
same
at all.
information?
No, it's the mandated person's role is only when you're unable to speak for yourself. So no, they don't have to be there at all. They don't have a right to participate in the decision unless they are the one making the decision. So,
Understood.
yeah, it's the user who has the right to participate in the decision. And then in the case where the user is unable to participate, only then would the mandated person step in. So it's not that you have your mandated person there with you having the conversation, unless you want some input from a trusted family, or friend, to help you make the decision. Then, of course, you could ask them for their input, but it's not required.
Sanja,
One last
we
question before I hand over to
question.
Lee.
I was just, while sticking on Christine's question,
Yes.
I read it slightly differently. She was saying,
Oh,
maybe we can just check with her if we've covered it up.
yes.
I think she's saying in Section 7 of the Act, does it not outline all the different options? And I think no. My answer to that would be no. Section 7 is just that it's whatever the treatment option that is being availed or is possible. Not always, sometimes some treatments aren't possible. There aren't enough dialysis machines, so dialysis isn't even an option. But if, let's say, dialysis was an option, it's the doctor's role to inform, and it's the user's role to either consent or refuse. Or if the user cannot speak for themselves, it's the mandated person. So no, Christine, there are so many options. No document, even a living will never cover all the bases. But it's the doctor's role that whatever is being offered, they have to make sure that you're well informed. Either the user or the man are well informed of the option that is currently being considered. Rhiannon,
right? Yeah, that's correct. And that's actually in Section 6. So Section 6 is entitled User to Have Full Knowledge. Okay, and that encompasses this idea of informed consent. And then it says that they have to explain the range of diagnostic procedures and treatment options generally available, the benefits, the risks, the costs, and the consequences generally associated with that, and inform the user of their right to refuse treatment. So that is what should be happening. It doesn't happen. I went to the doctor the other day, and there was no way that they did any of those things with me. When they offered me some medication, they didn't tell me what the risks were, what my other options might be. It was like, I think you should take this. And I was like, yes, I definitely need something. I'll take it. So I was complicit in that. But the Section 6 actually sets out in some detail what needs to be explained. And that is what is considered informed consent. So I think that might add something to it.
Thanks very much. We hope that covers you, Christine. Give us a thumbs up if yes, and if not, we can definitely chat to you offline as well. A last question before I hand over to Lee. If you have a Section 7 mandate, can we assume that there's then no need for a curatorship?
So that's a good question. The curatorship is a much broader kind of thing, because when a person loses capacity, they can no longer function within the system, in that they can't make decisions around their finances as well. So a curatorship is such where it deals with much, much more than just consent to medical treatment. But certainly, and you might have someone who has to go under curatorship, but has done previously a Section 7 mandate. That mandate would still apply, because remember, the mandate is the one thing that we have in our law that actually endures beyond the loss of capacity. But when it came to other decisions, such as financial decisions, you would need the curatorship. And I mean, that's an area of law that's very old-fashioned, and really does need to be overhauled. But I don't see that happening anytime soon. So it's really, there's this whole area of law is ripe for review. But it's amazing that some clever person came up with the mandate and put it in the National Health Act. So we have something at least.
Well, they did hide it away a little bit,
They did
but
hide it away. I think they
we'll
snuck it
forgive
in
them
there.
this
I
one time
actually would
since we
love
now
to know
know.
who drafted it. And I think they snuck it in.
Rhiannon, thanks so much for the wealth of information. As you can see in the chat, I think people are having their eyes opened tonight and really finding the information very valuable and would even like to share it with others. I would like to give Lee a chance now to speak to the audience about a couple of things before we close off for the evening. Lee, over to you.
Thanks so much, Sanja. Thank you.
Thank you, Rhiannon. And I think people, it's not often you go to a lawyer's website and there's a quote by Rumi. Rhiannon, as everyone can see, is a very different kind of a lawyer. And if you want to make contact with her or use her services, her practice is called Milkwood, and the contact details are at the bottom of the page. I also put them on the chat. Thank you so much, Rhiannon and Sanja. Wow, we're so lucky at DignitySA to have someone like you being on our board and guiding us. People have said over and again how clear you both are, how professional this is. And people can read more also about something called the Advanced Directives Campaign. I'll put that in the chat box too. So just to say, some of this, when I came across this information, sounded a little bit too good to be true. It was like, it can't be that simple, right? But we've actually spent, Rhiannon, Sanja, many doctors, many lawyers, more than 6 months now diving into the law, consulting with even a former Deputy Minister of Constitutional Development. And we are very sure about our position, so much so sure that we're actually, the next step is to form a coalition around this with other organizations and approach the Minister of Health to flesh out the law a bit in the form of regulation. So anyway, if you want to learn more about that, follow Advanced Directives, and I'll put that in the chat too, or just go to DignitySA's website. Here are a couple of resources you might be interested in. The most important one, I think, is at the bottom where it says you can find our resources at. So if you want that template for a Section 7 mandate came up too quickly, you'll find it there. We've also got a planning guide if you're thinking about these issues and just step-by-step going through it. And then if you sign up as a member for free, you will get also a template for a living will, and a template that combines a Section 7 mandate and a living will, and other resources and invitations to webinars like this. So it's free. We'd love your support. We'd love you to join our community, and you can do that by becoming a member. You've read about our campaign. It's going to be 5 to 7 years at this rate before we, if the courts find in our favor, Parliament still has to write law. It's 5 to 7 years before medical assistance in dying is legal in this country, and we operate as an NGO. So we need all the support we can get to make sure that we're still around in 5 to 7 years and continue to lobby and advocate. So we'd really appreciate any donations. Another easy way that you can show your support for our work is signing our petition if indeed you do believe that medical assistance in dying should be decriminalized. There is a petition at Amandla Moby, and also if you go to our homepage, you'll find it on our homepage. Also on our homepage is more about our court case and a direct link to being a member. Stories are powerful, and it's not just stories about, I know someone who's in tremendous suffering. Someone shared a story with me the other day that I'm going to post on our social media platforms. I think, no, she's not in this call, but she said her husband did have a living will. And even though, as you've heard tonight, technically living wills are not legal, the doctor respected that. And that's a powerful story to be able to tell, that having these documents helps and does make a difference. So you can pop your story in a voice note or go to our contact page, but we're always looking for stories, both where dignity has been heard and respected and where it hasn't. It's a powerful way to convey why this work matters so much. So we host these Dignity Dialogues every month. Next month is probably going to be on living with dementia, which is obviously a topic that touches many of us too. But if you sign up as a member, we will definitely keep you updated about those. We will post this recording on our YouTube channel, and everyone who's registered will be notified once that is available. So stay in touch, and we look forward to, and please, most importantly, perhaps, share this information. It's why we're forming a coalition. We've got a lot of work to do. Just take medical assistance in dying off the table just around advance directives. With everybody, our goal is to have 1 million South Africans, people over the age of 18, having an advance directive. That's an ambitious goal. But that in itself will make a huge step forward for dignity at the end of life. So please share the information. It's widely, and encourage people. Soon, we hope in a few years now, success looks like everyone knows what a section mandate is. It's common parlance. It's used more widely than the notion of a living will. And we need your help to do that. So take this information, share it. It's free information. It's important information. And thank you for everybody making the time to come and learn about this and being a part of this very powerful and very beautiful community.
Thank you so much, Lee. Thank you for organizing us. We really love you. And to you, Rhiannon, our gratitude for being with us tonight, taking the time and sharing your wisdom. And to everybody who joined us this evening, who made time to come and listen and learn about Section 7 mandates, we encourage you, as Leah said, to go and have conversations and to write your Section 7 mandates straight away. I hope you have a wonderful evening and good night.